Greetings, welcome to thctrust.org. Visit the website, click this link right here. It says create a new account. And after you create a new account, go ahead and log in. And go under the personal status correction menu, which is where the secured party creditor filing information is, your trust setup, and everything else. This is my fourth time making this video because the other three attempts, I went back and listened to it and I was just like, man, I just don't think I'm getting the information out that I'm trying to convey in an understandable manner. So hopefully we could do it this time. Personal status correction menu. The last video we left off with was talking about the power of attorney. And that's kind of step two. One is name and address correction, which we went through. That's how you set up the private address for the private individual, the name to delineate the capacity from the actual estate that was created when you were born. Then we talked about the importance of having an agency agreement on record. Once again, the agent can bind the organization to contracts, but the agent doesn't necessarily have the liability. And quite frankly, the agent is really who the private individual is. So we want to do any business for any business for the public as a private representative. So basically that's a private representative for the estate that was created when we were born. Or an executor, because in estate and trust law, an executor is a private representative of an estate, and also an estate is a trust. We're going to talk more about that. So I've always been saying this estate that was created when you were born, but in reality, I'm talking about a trust because an estate is a trust. Coincidentally, when you apply for the tax ID number for your estate, you should be applying for a trust tax ID number. The only time you're going to apply for a tax ID number for an estate is for a decedent's estate. And you don't have a decedent's estate as long as you can hear the sound of my voice. Okay, so even though the entity or the organization that was created when you were born is not a living thing per se, no entities and organizations are, but it would be a misclassification if you looked at it as a decedent's estate and you called the IRS and applied for a tax ID number for a decedent's estate. And many of us has done that. I've done it before, but that is not correct. But neither here nor there. We will talk more about that as we get further into this video. But step two was about the power of attorney and the agency, setting up the agency. And now we come to step three, which is the trust to control the estate. Excuse me, I'm going to take my time because I don't want to miss anything in this take, and I want to sip on my little coffee here. So one of the main questions people have when it comes to personal status correction and secured party creditor, and I want to get out the system, I want to operate correctly, is how should I set up my trust? Because no matter where you learn, you begin to find out that there's a trust element to all of this. And I need to know what type of trust should I set up to be free, right? Generally speaking. And now you have these options of revocable trust or irrevocable trust, common law trust, express trust, living trust. Somebody told me I should do it this way. Somebody told me I should do it that way. Let me give you my perspective and my take on it. And my perspective and my take is also reflected in our personal status correction outline. First thing that's important to note is that your trust instrument typically is going to be private, right? This is not something that you're going to show to anybody. So in that case, that lets you know right there what's most important is learning how to operate these trusts or understanding the trust relationships. What benefit do I have by having the knowledge and understanding how to operate a trust or how trust operates? Because really, this trust that I'm supposed to be using to control the estate, no one can ever see it, or they're not supposed to see it. I don't have to show anybody. Now, I will say, there may come a time or an instance in your life where you, as the trustee for that trust, make a decision to show the trust instrument to an agent or to a contractor or to somebody that you're working with for whatever purpose. That's for you to make that determination. But until that occurs, generally, the trust instrument isn't shown to anybody, right? Furthermore, let me note you that a trust instrument does not need to be notarized at all. I'm mentioning these two things together because if your trust instrument doesn't need to be seen by anybody and it doesn't need to be notarized, do you really actually have to have a trust instrument to have a trust? The answer is no, but the majority of any trust that exists is going to have a trust instrument. Okay, so just think about these things that I'm laying out because they're going to kind of be answered as we go through this. But these are the kind of the things that I want you to consider, because when you are trying to figure out what trust should I use and all of these things, I don't think it should be, even though I'm going to tell you my opinion, I don't think it's so much what you want to go with what somebody says. It's you want to move in accordance with what you understand and what your objective is when you're doing these things, right? So a trust, for one, I would just say, for the first question, whether you should use a revocable or irrevocable trust. And usually when well, first let's say the answer. It's a revocable trust, right? Revocable trust means the settlor who put the property in trust or who uh, declared the trust, or basically the settlor still has rights to the property. He can revoke the trust. He can amend the trust, right? He still has some control over his property during his lifetime. This is another reason why I say the estate that was created when you were born, which is actually a trust, a property holding trust. This is another reason why, if you look at that trust, right, it's absolutely revocable. I mean, well, let me not put it in these terms. I guess what I'm trying to say is, as long as you're alive, you can do what you want to do with your property. You can lease it to somebody and you can get your property back. So look at the default situation of a trust. Unless by the terms and the conditions of the grantor, he makes it irrevocable, then by default it's revocable. So first, when it comes to all of these types of trusts, revocable versus irrevocable, living trust, family trust, anytime you put, I would say from a starting point, we're talking, you need to have a trust to control your estate. From your vantage point to your advantage, it's only a trust. There's no beneficial reason for you to put terms and conditions on your trust. When you call a trust a living trust, you've added terms and conditions to the trust. When you call it a family trust, you modify a basic trust and you make it into a family trust. Whatever those terms and conditions are may be debatable, but you add terms and conditions to it. The same when you call it a revocable trust or you call it an irrevocable trust. Really, all of those terms should be determined by what is written in the trust instrument, right? And this is always the case. I'm not saying that it's wrong to call your trust an irrevocable trust. I'm just saying overstand this so that if you do happen to use these terms, you're very cautious when and how you're using them and the effect that you want to have. But don't think in these type of terms. For example, you hear people say, my 98 trust. There's no such thing as a 98 trust. The trust itself is what offers the foreign protection, or the the coverage by protecting it from the foreign jurisdictions. It's the trust, not the number. But that's what I'm saying. Don't get caught in terms. What's most important at the fundamental thing, what we're trying to do is understand trust technology. Trust technology to apply it in a meaningful way to control our estate. So for starters, we're getting into what type of trust. But for starters, all you need is a trust to control the estate. Now, to throw some terms and conditions on what type of trust it is to make it easier for you to grasp, let's say a living trust is where you start. Okay, so if you will, focus on the screen here. I'm going to make it bigger. Oh, not this one. All right, we're still on the screen here. And as I've showed you before, so we'll talk about a trust instrument. Every trust has a trust instrument, generally speaking, because there can be a trust that doesn't have a trust instrument. And from the trust instrument, right, you can derive a trust registration statement. It's like a legal identity for the trust. Just like everybody has a name and they have an address and they have a birthday, right? And from that information, you can generate an ID card to identify specifically that's that person, right? It's kind of specific because you're like, this is his name, this is his birthday, this is his address, that's that person, here's his identity card. This is kind of how you look at a trust registration statement, right? If you want to positively identify a trust for whatever reason that comes along, it will come along sometime in commerce, especially if you're really in this thing, like you're changing how you do your life because this information is changing the way you operate. These are little things that you have to know. Don't get wrapped up in, oh, but I'm just trying to do my secured party creditor. What does this have to do with that? This is something that you just need to know. You're going to see this somewhere. You're going to have to use it somewhere. But this is important. So I'm just trying to explain. This is why we have trust registrations or trust registration statements. The Treasury uses them. They use this in Treasury Direct. If you've ever set up a Treasury Direct account, if you look closely, there's somewhere in there when you're setting up the application where they generate this registration statement. Certain attorneys use this on UCC filings. You will use this in different places, so just understand the usage of it. Now, one of the places where you can find out, understand this better is FS0049. It's Treasury publication. We always talk about it, but let's go through it. FS0049. Pull it up here. You can Google Treasury Pub FS0049. It'll come up. One thing I like about this right here, so I'm going to show this right here since we're on it. A trust is real or personal property held by one party for the benefit of another or one's self. This is the part I wanted to get to. Every trust must have, oh no, down here, this statement right here. And then we're going to move on to the trust registrations. The grantor, trustee, and beneficiary may be the same person. What do they mean by that? How many people have told you they can't be the same person? And it's not to say that those people were wrong. It depends on, how they, it depends on the context of the conversation, of course. But again, this says that grantor, trustee, and beneficiary may be the same person. But as far as the trust is concerned, they are three separate entities. So this is what's really going on here when we're talking about John Doe L, private banker for the estate of John Alex Doe, filed on whatever date. Now we're just talking about the various capacities of people who operate within the trust that was created when you were born. So let's look down again to the trust registrations, which I was saying these are like ID cards. This is like the identity. This is like what ID cards are to people, right? It's not really you on that identification card, but it's made up of certain attributes, name, address, etc. So is these trust registrations. Here's the one that this is the trust registration that I use generally, that people use on, with the trust that we're about to look at, because it's, so say I just executed a living trust. I just woke up today, realized that there was a state which is already a trust, but I didn't express it. But it's doing business in my trade name. It's a property, it's holding property. Some of the property I so-called think I own because it's in my name and I work with it every day. But then I come across this knowledge and I want to express a trust. I want to express my relationship to this property holding, and I want to collect all the property the same way that an executor would do for a decedent's estate. The executor for my living estate, or the personal representative for my living estate, at some point needs to file a security interest on all of this property. So you're going to express this trust and you're going to create a property list to show all of the property that you're aware of that the trust holds title to. This already exists. You had bank accounts in your name, right? So those are some types of property per se. You have cars, vehicles, personal property, real property. So this estate that was created when you were born already exists. It already has its own trust instrument, which is your certificate of live birth. But now that you're expressing a trust to control the estate, you're basically writing that trust out. That's going to be well, let's say like this. You're going to make a declaration or express the trust that controls the estate. And that's going to be a new trust instrument based on today, April 25th, 2025. So the trust instrument for that day will have today's date, or whatever date that you do this on, right? And it'll be something like this. I would be saying, Paul E. White, trustee. Oh, no, not there. Here we are. Paul E. White, trustee, under declaration of trust, dated 2/1/05. So see, in this trust right here, right, and quite honestly, we're the grantor, trustee, and beneficiary in some capacity. That's why I was saying, that's why I was directing your attention on earlier, where they were saying they may be the same person, but as far as, where's that? Here it is. Let's read it directly again. The grantor, trustee, and beneficiary may be the same person, but as far as the trust is concerned, they are three separate entities. So we're talking about capacities. The grantor being the organization on a certificate of live birth, the trustee being you in your as a private agent, or in your private capacity as relates to that organization. So that's what's really going on here. So this trust registration is for your living trust. It'll match up to your living trust. Paul White, trustee, under declaration of trust. So I'm looking for a declaration of trust with this date on it, right? Here's the abbreviated version. Paul E. White, TR, U/D/T, under declaration of trust, dated 2/1/05. Okay, let's see. All right, so we get this. We understand these trust registration statements now. So there you have it. Here, let's look at this last one. Paul E. White, Mary White, Sally Smith, Bob Jones, Tom Black. So if you ever need to figure out how to write a trust registration statement, they got an example for every type. These will give you the basics. Sometimes you may have to go outside of this, but you'll understand it after this. And Beth Jones, trustees. They're all trustees under the will of George White, deceased. And then these are the abbreviated versions of it. So there you have it. That's from FS0049. These are our trust registration statements. Let me explain them real quick. John Doe L., trustee, under declaration of trust dated 5/15/89. That's kind of like a living trust. We just kind of went through that. This, if you looked at your birth certificate as a trust instrument, this is the type, this is what the syntax for its identification card will look like. Or as I was saying before, the trust registration statement. We have John Doe L., general executor, which is actually a trustee. And notice we're using the private capacity name. We've already set up everything for that. Published nationality, private mailbox. We using the passport card, operating as a national. John Doe L., general executor for the John Alex Doe, filed 5/15/68. This is this filed number. You'll see it right on your certificate of live birth. It's the date after your birth date. It usually says filed or received, but there's another date on there. That is the date that I attribute to the date that this estate was opened, the books were created, or it was founded. And this is the number. This is the actual estate number. This is found on your certificate of live birth. What this number is, let's go back here. This is actually on ssa.gov, but here we found it on vitalrecordsonline.com. A birth certificate number is an 11-digit identification number found on official U.S. birth certificates. Each number is unique and assigned when the birth certificate is registered with the state's Vital Records Office. Official proof of birth. And it says you need it for obtaining a passport, applying for a driver's license. All of your identity documents arise out of this. Here's the code right here. This is called, represents a state or territory where the birth was registered, the first 3 digits. So 1, 2, 3. So again, this number, is your state number, quite frankly. And you can, this is what this represents in the trust registration statement. So without ambiguity, this identifies the estate that was created when you were born. It's using your trade name, John Alex Doe. This is the date that it was filed. You will find that on the actual trust instrument. Here's the actual identification number for the estate. And your private capacity as a private executor, general executor, private attorney, private whoever, as relates to it. These are the trust registration statements that we use for the trust that controls the estate. Mentally take a note of it because somewhere along the way you will use these. For example, I'm going to show you where we use all 3 of these, or at least 2 of them, because 1 and 2 are the same. This is an abbreviated version of John Doe L. trustee under declaration of trust dated 5/15/89. So let's move forward real quick and look at the UCC1 financing statement, which we're going to talk about the national filing next. So I'm going to click this so we can take a quick preview and scroll down here. This represents the actual master discharge indemnity bond that gets deposited with the United States Treasury. But what we're looking at here is the UCC1 financing statement. This is basically a UCC1 financing statement form. This is my own form per se, but it matches up, the numbering matches up with the UCC1 national form. And in the national filing office, you don't have to use the form. You can present your security interest in other formats. So this is a customizable format, but so that it can be easily understood, the numbers match up exactly as they would on the UCC form For example, you have box 4, then you go into collateral. You got box 3, which is a secured party. You actually have 3 and then 3A, which is an additional secured party. We're using 2 secured parties. The secured parties in this examples are trusts. This is one place where we use trust registrations that we just looked at and learned. Let's zoom in here. First, let's look at the debtor. When you do a national UCC filing, and this is not the real subject of this, but I'm just going to state it as some extra information, the debtor can be an individual or the debtor can be an organization. And people say, well, which should I do? I say you do both. And because it's beyond the scope of this video, I'm not going to explain why. But I'll just show you. This is why I like, and because the regulations support that you can. And this is why I like doing the freelancing it, or not freelancing it, but using my own form. So here we have the debtor's name, John Alex Doe, U.S. Administrative Estate, and then we have the estate number. Up here, this is debtor is an organization, not an individual. The UCC says if you put an organization, you have to put the entity's identification number there also. So that's why we have this. John Alex Doe, the type of organization. They want you to write that also, U.S. Administrative Estate. And then that's the identification number. There would be places on the UCC one form where you could see this too if you had the form up. Then the address. But then also down here, debtor's an individual. John A. Doe. Why is he an individual? Because it's also the individual suretyship that they created out of the estate with the social security number. That's the debtor too. Now, again, now let's go to the secured party. We already said the estate itself was the debtor. So the secured party then has to be a capacity type of thing, right? Secured party. John Doe L., trustee under Declaration of Trust dated 5/14/2023. That's the living trust instrument that we created to control our estate. And this is just an expression of the trust. When you look at the certificate of live birth, which is the estate that was created when we were born, it's a trust that was already created, right? What is our relationship to it? General executor, the one who's responsible for collecting and controlling the property. So this is just an expression. The trust instrument is the certificate of live birth itself. So this would properly be John Doe L., not John Alex Doe, but John Doe L., general executor for John Alex Doe, filed November 7th, 1967, or whatever the date of birth is, and then you'll have the estate number. This will all come off the certificate of live birth. So now there's no ambiguity. You have the revocable trust that you just created the day that you woke up. You express the trust, you execute that instrument. That trust is a secured party, the trust that controls the estate in this UCC filing, but also the private banker for the estate of John Alex Doe, or private attorney general or private executor for the estate of John Alex Doe. That expression of actually it's John Doe L. trustee under Declaration of Trust. That's also the secured party. Or excuse me, you see where I'm going with it anyway. These are your secured parties, and this is an example of where you might use a trust registration. All right, that being said, let me take a breather for a moment. Now let's look at, now also I don't get it wrong. Although I'm saying a revocable trust to control the estate, there's reasons. I mean, the majority of the trust that I use when I do my business or when I'm operating in commerce, they are irrevocable trusts. They're more like business trusts, right? But again, that's not what we're talking about. We're talking about the trust to control the estate created when you were born. We're coming from the standpoint of personal status correction. We're not coming from the standpoint of asset protection and some of the other general things that trusts are fundamentally used for. So don't get it twisted. Those, it's not, those absolutely are necessary trust instruments, when you talk about irrevocable business trust and things like that. But that's not the focus of personal status correction. So don't get it twisted in that sense. I'm not saying that the revocable trust is better than another trust. I'm talking about applying it to operating and navigating correctly. So also to give a little forethought, where I'm at with this is the reason why you're setting up the trust to control the estate, applying for the tax ID number and setting up this private entity is because eventually these are going to be the utilities that you use for private banking to tax and return certain interests that owes to your estate to get the real equitable remedy of why we're all doing this, getting to the bag the correct way, per se. This is what it's really all about. Uh, Administering the estate, assigning beneficial interest in income or assets, and doing these things in trust, which may be disbursements between the trust and beneficiaries, trustees, assignments of beneficial interest and conveyance of such things. This is why, but I'm putting this together. I'm throwing pieces out there, but just to show you when I'm setting this stuff up, or the way that we're setting things up is because once you see how this stuff is operating, you want to express it and put the utilities in place, because when you're administering it, you're going to be the one at some point responsible for conducting the transactions and making sure that your will is carried out while you're alive in the living trust, per se. I hope I'm not just rambling on. I hope that makes sense, because it's kind of hard to express what I'm trying to get you to see. Let's see. So what else? Anything else we want to look at? Okay. Let's look at the trust instrument that we've been talking about. Again, this trust instrument that I created is more for you, as it always is. Like, even when I go open up a bank account, I know I have to bring the bank trust documents. So I may create a cover page for them, because I already know what the bank is looking for when they're trying to figure out, can I open up an account for this trust or whatever. So I create this cover page. This is not really a part of the trust, but if I have to show the trust or any part of it, a memorandum of trust, a certification of trust, to any person for a particular type of business, I already know what information they're looking for, and I try to put it all in one place to save any back and forth, so they can just look at it and then keep it moving. Because a lot of times you're going to find, and I'm just giving you general information, it doesn't necessarily apply to personal status correction. A lot of people don't know about trust. They have to do research, or they have to escalate. So they're really following some instructions that they got somewhere, and you don't really want them trying to dig through your trust to comprehend anything or to find anything. Just put it all there so they can get it and go. This really would probably never be used, because it might be used, but I don't. The majority of you probably don't need to open up an account for this trust that controls your estate. You could, and something else I would say. Um, Generally, a revocable trust, when you open up the bank account, you open it up as a living trust. But so the trusts who can operate, maintain property as an entirely separate entity from their owner typically are not living trusts. So just be aware of that, right? It all comes down to how you operate and how you navigate, right? So that's why I say you really, so what I'm saying is, when I never ever opened up a living trust account. So let me be completely transparent. Even though I'm telling you right now that operating in a living trust is the trust to control the estate. It's not, again, as I said earlier, it's not so much about it being a living trust. It's the fact that by default the trust is revocable during your lifetime. So if you just went to open up a bank, they see you're the grantor, you're the trustee, and they understand it's revocable, they're going to treat it and set it up like a living trust account. I've never done that. I've only opened up business trust accounts and things of the such. Because and my reason is because although a revocable trust controls my estate, any money that needs to be put into a bank account is for business purposes, right? And you know, I don't want to, I think it's more beneficial to hold funds in a business account, because a business account or a commercial trust account or a business trust account is the bank is treating the trust entity as entirely separate individual from the owner. If they're opening up a revocable trust account for you, they're not going to treat it that way. That's just some extra information, just so think about that. You still, I believe, you want a living trust to control the estate, but when you open up a bank account, you might not use this trust instrument. You might use a different trust instrument. You might open the bank account with your foreign tax ID number or with just something else, but not this, right? That's just my suggestion. Excuse me. Actually, I take that back. You can use this. You can use this also. Just be aware of what I told you. Be paying attention when they're setting up the account, because a lot of times they're going to be setting up the account right in front of you, asking the questions out loud, trying to determine the answer from your paperwork. And if you understand what's going on, you could kind of tell them how to set it up. So you can use this basically, but what I'm saying is I believe it's more beneficial for you to let them set up the bank account in such a way that it is not considered a living or revocable trust. You want this, that's just my opinion. Leave it like that if you was going to the bank. Now let's go get into it. This is the cover page. So this is the trust instrument down here. Like I said, it's just one page. And then at the bottom, we have a property list where we're listing all of the property. Deposit accounts, security interest in promissory notes, anything that I think of that I think is actually value, I want title, in my trust, because there's an interest owed to the estate, which has to be managed by the private representative. So basically, we are documenting and opening up the books of the private estate. So we want the property list to create all of those accounts, and then we want all the tangible personal property too, and all the real property, all the property you're aware of, you add it to that property list. This is the one-page trust, and actually this is a memorandum of trust. Actually, it's more than that. I had the liberty of doing this however I wanted to, because there's so many different types of trust instruments, and nobody knows what the original trust instrument is except for the original party creating the trust. So usually a memorandum of trust isn't the original trust instrument, but in this instant it is. This one pager represents multiple things. The minutes of the initial meeting for John Alex Doe, executor for the John Alex Doe filed November 7th, 1967. Remember, that's the first estate trust. So this is the minutes of the meeting for that trust doing business under the trade name JAD Private Bank and Trust. This trade name could have been anything, but the JAD is John Alex Doe Private Bank and Trust. In my case, it's SDM Private Bank and Trust. And you'll see later on why we designated and chose this trade name for the business name of the private side of the estate. And by the way, this is the estate. That's what we didn't look at. We're going to go look at that. We know that this is the trust registration statement for the estate when you look at the certificate of live birth. But we have to apply for the tax ID number. This is actually the trust instrument now. But this is the minutes for the initial meeting of that trust, right? You might have been born in one year, but when you actually executed the trust to express, when you executed the trust instrument to express the trust controlling that estate was a different day, which is more present. That's going to be the date that you put here on this instrument. So this is the minutes for the initial meeting of the estate. It's the initial meeting because you're of the age of majority, you recognize what's going on, and now you're about to declare and express the trust as it exists. This is the initial meeting. You're the only one present. Maybe you have a witness there too. Here's the date, here's the time, and by the way, this date, this is your new trust instrument. So John Doe, trustee, under declaration of trust, dated whatever, this is the date. I, John Doe, and here's the trade name, John Alex Doe Private Bank and Trust. I, John Alex Doe, see, oh, let me say something else too. Don't get wrapped up in this trade name. This is a strategic, this is put here strategically, and you'll see why. Because the trust, the trustee has the right to do the business of the trust in his own name, even like the estate is doing business in his own name or in the business name of the trust. John Alex Doe Private Bank and Trust. You'll see that in the terms. I, John Alex Doe, the undersigned, affiant, domiciled at 123, private address, hereby declare and affirm and state the following. I am above the age of majority, fully competent to make this declaration. The statements herein are based on my personal knowledge. I certify that a trust exists holding property filed in Trumbull County, Ohio on November 7th, 1967 under identification number 123-45-6789, hereinafter referred to as the estate. The estate holds property under the trade name John Alex Doe and has remained without formal administration until the date hereof by which the undersigned affixed his signature upon this instrument. On this date I was present and constituted a quorum of the board, at which time I voluntarily accepted and assumed the duties and responsibilities to act as a trustee and general executor for the estate. I am in possession of an authenticated record evidencing the existence of the estate, a copy of which is attached and considered a part of the res of the trust. This one-page memorandum is attached to the certificate of live birth. You get that? The one page. That's why I said in paragraph 5, I am in possession of an authenticated record evidencing the existence of the estate, a copy of which is attached and considered part of the trust res. I could put it, so you can do that. You don't have to attach it. You could identify it and say incorporated by reference or something like that. This estate is held in revocable express trust under the legal name John Doe L under declaration of trust dated today, right? That's what this trust instrument is. The trust is doing business in the trade name John Alex Doe Private Bank and Trust and exists as a separate legal entity from its owner and may take, hold, and dispose of any interest in real or personal property in its name or in the name of one or more of its trustees. Again, usually this provision right here is not something that applies to revocable trust, and we have a revocable trust situation here. So just be conscious and aware of that. This could be an issue somewhere, and I mean it could be an issue as far as somebody setting up your trust account as a revocable trust account or irrevocable trust, or it may or may not be an issue. Just be aware, right? Just be aware, because a lot of this is about having the knowledge of how to navigate as with your trust in different situations. So I say be aware because when the situation arises, you can make a determination and at least you know what's going on. In the event of my incapacity, resignation or death, Sandra Jones, residing at 123 Private Address, has been designated to serve as successor trustee with full authority to administer the trust and carry out its terms. For the purposes of receiving correspondences and notices for the trust, I hereby appoint the mailing receiving agent, Civic Mailing Center, 789 Federal Ave, etc. So this is a trust instrument. This is the initial meetings for the estate created when you were born. Those initial meetings were declared in an affidavit form as an express trust in one page with a witness signing off on it. That witness could even be the person appointed successor trustee. You can execute this instrument today, and now you have the trust that controls the estate. Basically, what you have is a document which is the foundational basis for the trust registration statements that you're using on your UCC1, that you're using on your SS4 application to apply for the tax ID number, because really we know the trust instrument should come before the tax ID number. So here's your trust instrument. And now any major modifications that you make to JAD, private banking trust, any amendment, any minutes that you keep, any changes, you add that to this private record and you put that with this private record that this is your trust instrument, right? This is your trust instrument and all the amendments that go along with it. Now that you have a trust instrument, now again, this cover page right here, all of the information on this cover page was taken right out of that instrument. Date of the trust, April, whatever the date was in the instrument. I'm not sure if this is right, but that's I'm just explaining how you use this type of cover sheet. Type, irrevocable, not for profit. So if they're looking for that information. Settlor, the estate of John Alex Doe, created May 11th, 1979. That's the trust registration statement for, it's not the trust registration statement, it's just the estate itself. Estate of John Alex Doe, this is the date that the estate was created on a certificate of live birth, and then you have the estate filing number and the county and the state or the territory. That's the settlor. It's actually, the settlor is an organization, right? The estate that was created when you were born is also known as an organization within the state and the way the state government looks at it. It's an organization, and sometimes it's referred to as, basically an estate. Now, who's the trustee? John Doe L. The person that you walk around, it's the same name that's on the passport. It's the same name why you put your affidavits and supplemental statements. You know, it's the same that you use the name correction. This is the trustee. He uses the private address because he's really the private representative for this estate. Successor trustee, another person that you name. The mailing address, just the general information. Now we got to go look at the tax ID number. I saved the tax ID number for last because actually, let me take a pause, take a breather, then I'm gonna come back and we're gonna go to the tax through the tax ID number. You don't call the IRS and ask for an estate tax ID number for your living estate because all they know is a decedent's estate, and they're gonna give you, they're gonna ask for the date, they're gonna ask you for the date of the death, and then you're gonna probably tell them something that's not so. This is the same type of thing you do with the 98 trust. They ask you for the country and you tell them something that's not so, but you rationalize that it should be done that way anyway. And again, I'm not the source or the authority, but the IRS recognizes estates, but they do so under the term trust. So you need an ID, you need a tax number for the estate that was created when you were born, but that is a trust. So you need a trust tax ID number. You shouldn't be using a decedent's estate tax ID number for the for the purposes of controlling your estate. Let me put it like that. The trust that controls your estate. That's what I'm trying to say. Now, and the name isn't so relevant. You know what I'm saying? You're going to be, where's it at here? I'm sorry. Here we go. Click down here. All right, this represents an SS4 form. I recommend that if you're going to apply for tax ID numbers and you want to be private and things like that, you already have a private address set up where you do your business from. You don't receive any mail in the public. So another way, so you always look at the opportunity to fax an application as another way to remain outside the public, keep your fees down, and you get to do everything on your time. You don't have to wait in no lines. You don't have to wait for any response. You don't have to wait for somebody to, you just prepare the form, sign it, fax it, and be on your way, right? If you have a fax machine. Now, there's also online fax machines, but I believe that sometimes if you get an online fax machine, you better kind of just do some research. I wouldn't just go with the mainstream cheapest one, because sometimes I think the IRS won't send documents to them. The IRS is very specific about when you apply for, if you apply for a tax ID number and you're doing business with them by fax, if they're ever going to fax you something, you got to be standing right beside the fax machine, or they won't fax it to you. And if they get the idea that it's not a secure fax, they won't fax something to you. That being said, if you got your own fax number, that's good. You can use an online fax, but just find a good one. Don't just go with the cheapest solution. Um, you know, I don't really know what that means as far as online faxes go, but I like to fax this off. You don't have to fax it. If I weren't going to fax it, I would definitely mail it. I would try to avoid doing it online. And the thing is, when it comes to what we're doing overall, you never have to rush anything, because we want to cross our T's, dot our I's. It's like administration, right? So there's no need to rush anything. Actually take your time and enjoy taking your time and doing things the correct way. So you can fax it or you can mail it. And then I like, the other thing about faxing it is when they return it to you, as you see here. Let's go look at this. This is the actual application that came back. You see they hand wrote the number in. It remains in uppercase, lowercase, the same way you wrote it, right? Because on a CP575, it's going to come back in all caps, I believe. But some people have an issue about all that, which probably is not really an issue in my opinion. But if it is an issue, at least you have a copy of the original application with them handwriting it in. They have entries in the margins. This is a very long serial number, and it's not even in date order. Let me look how many digits this is. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. It's a 10-digit number. Pretty long there. They put a stamp over here on this side, you can see. And I use the eFax service, as you can see. So anyway, don't get wrapped up in the name here, right? You could use your registration statement here. I'm going to explain the reason why I don't. And we seen earlier, we used the registration on the UCC financing statement. I'm explaining these little things so you can understand more nuances about these forms and strategies when you apply for different things, because some of this stuff may be helpful for something else that you're doing. Well, one thing is, well, first we'll come back to that. First, I want to point out something. This is the trust that controls the estate. So the first thing I want to point to is the responsible party. The responsible party is the name on a certificate of live birth. John Alex Doe, for say. In this example, Sylvester Moore, or it should be, you could put Sylvester Dylan Moore or Sylvester Moore. In this case, it doesn't matter because you're naming the responsible party, and then you're writing the social security number of the responsible party. So now there's really no ambiguity, because I now have identified, the organization who is the responsible party for this transaction, if you look at it if you would look at it like that as a registration. So that's the responsible party. Again, this isn't me doing this, right? We're dealing with capacity. This is the actually, this is not the organization that was created when I was born. There was no social security number when I was born, was it? That came after the fact. So this responsible party is in a different capacity. The capacity with the social security number, it's an individual surety, is what I call it, a suretyship organization. Whether we know what it is, we know how it operates, because we're very used to using the name and the social security number, right? It becomes the responsible party, the obligated one. It's the account that's going to be charged ultimately, right? That's what it is. So the name of the responsible party goes in box 7A. The responsible party's number goes here to show he's the obligated one. See, right? Once again, when people use constructive trust, they're using this responsible party for their purpose. In this case, this is not a constructive trust. This is an express trust that you're creating, but you're still using the responsible party. You see how that is? What's the trade name of the business? This particular business trust, as I was saying earlier, The trustee is authorized to do business in his own trade name, even as the estate that was created when I was born is doing business in the private representative's name right now. Now that he's expressing a trust, he could do business in his own trade name, or he could do business in the trade name that the trust has delegated, which he has delegated, and it's in the trust instrument. I don't want to flip back over there, but we just took a good look at it. So I didn't use the trust registration statement. I used the trade name and the trust instrument, and I'm about to tell you why. SDM Private Bank and Trust, right? Because the reason I did this is because when this comes back on a CP 575, for one, I don't want to add extra information that I don't really need to be on. I don't want my trust registration statement out there in the public. I provide the trust registration statement for certain transactions in commerce that requires me to present certain information for the trust. I want to keep this minimal, right? Just keep this minimal because it's going to come back in the mail, tax ID number on it, and you never know. Maybe I have to display a document, to somebody to show that, hey, this is my tax ID number. I just don't want all the extra information on my CP 575. And another thing is, if I were to give the whole name for the trust instead of just the trade name, right? John Doe L, trustee under declaration of trust or whatever. What if at some point John Doe is incapacitated, or some kind of way the successor trustee becomes a trustee, or there's another trustee? There's no problem, but I would rather, if the trustee has all the paperwork and all the documents, the trust instruments and all the documents that go along with it, it'd just be, on all the tax paperwork, it's still going to have the original trustee's name. So it's better just to have the name of the trust. Also, for the purposes of, there's other reasons too, but I don't want to go too long. So, but you could, now again, you could do it how you want to, but I'm just kind of sharing. As with everything I do, there's a rhyme and a reason, and I researched or I came across something of why I decided or chose or figured it was supposed to be this way. So not saying that you have to do it this way, but it is beneficial. For me, this is definitely beneficial to do it this way because, as the general executor for the estate or trustee, I have the power to appoint another attorney or private representative or whatever, right? I can step down out of any position. See, I have the power of attorney, right? The legal rights of the trustee of the private estate, beneficiary in some capacity. So it goes back to what the Treasury says. It's about capacity in reality. And the way that the trust instrument for the living estate is created is that in the event that you are deemed to be, unable to perform a specific transaction due to your proximity of the trust, you have a successor trustee, or you can appoint or elect somebody else to do so, right? So you could just hand them the trust, Anyway, this makes it easier for administration. That's why I pretty much did that. So, but the thing is, here's something else that I want to point out before we move on. The trade name of the business, if different from the name on line 1. Well, the trade name is the name on a certificate of live birth. Do you see how many people's using it? The organization that was created when I was born uses that trade name. The individual suretyship that they created after I was born with the social security number and all of that uses that trade name. I have a sole proprietorship that uses that trade name, and I have a trust. And this is an example of how I apply for the tax ID number for that trust that controls the estate. And these are all separate entities, but they use the same trade name. I'm explaining this like this so you can kind of see these different capacities and how they're operating, and don't be like, oh no, I'm not the straw man. I can't put my social security number on the form because now I want you to think about it. Somebody tell me if I'm incorrect. And why would you not want the individual suretyship corporation to be the responsible party for a trust that you're using to hold the estate and commerce? Why would you not want it to be the responsible party? because there's got to be a responsible party. I mean, it's just like a promissory note. In this commercial system, the promissory note doesn't have any value unless it can be charged to an estate, unless it could be signed by somebody who becomes, verified. So, they verify your estate, verify who you are. So that's what I'm saying. They verify who your administrative estate is, whether it's by identification documents that you provide or social security number, so that then they can charge your estate to complete the transaction. Because somebody got to be the ground and the source. Is the way that I kind of look at it. It's the same thing, except for the instrumentality that the government created for that purpose. They use it to facilitate commerce, and I have to do the private records in the book so I can facilitate commerce and so I can administer the private estate. But either way, I'm just kind of rambling on. Man, this has been a long video, I know, because once I tap this one on top of what we did yesterday, yeah, this is just a long video. So thank you for sticking in there, listening to it. This was a difficult video for me to do. I just really don't know why. Sometimes these videos is easy to do, but this one is just difficult because these are some unique concepts to understand, in my opinion. So please give me some feedback. Let me know if you were able to comprehend or understand anything out of this, or was it just like, maybe I got to go back and make this one again, and maybe I will, because this one was a tough one to make. But again, thank you. One other thing I'll say on here, there's nothing, so you can, do this, tweak this however you want. That's why I explained how it is, right? You can do whatever you want with it, but I would just say, whatever name you write here, make sure it's also in your trust instrument. Your trust instrument actually comes first, and then you apply for a tax ID number based off of that trust instrument. So make sure what you have here lines up with what's there. Don't get fancy and check this box. Don't write private unincorporated banking association. If you're using this template, I was just trying to be fancy and wrote something like that. But me doing that made them misclassify the trust as a partnership, because when they see unincorporated and association, they're thinking partnership. And when I got the CP 575, that was what they did. So you could just kind of click this box that says trust, and then they ask for the tax ID number of the grantor. You could do what you want, but I would just personally leave it blank. And then yeah, that's all the other stuff. Like all this extra fancy stuff I was doing, don't put nothing else down there. You gave them all the basic information. For the purposes, banking purposes, and then they say specify, managing private assets and settlements. That's what I wrote. You could do something to that effect. But that's all it is for. That's the only thing this account is for banking purposes. Redemptions, redemptions of property owed to the estate, not property owed to you as an individual, property owed to your estate. And that's a key, something that I think people ought to focus on, because there might be a remedy in there. Sometimes you're trying to redeem or do certain things in the wrong capacity, right? This is why I always say there was an estate that was created when you were born. Who are you as relates to it? Because if you're not doing any administration, a lot of times you don't even see it, and you leave everything on the table thinking that you're going to be able to do something with a dead man's will. Anyway, peace and love. I'm up out of here.